the recording. I hope you can hear me. I can't speak very loudly. I had a little bit of operation last week, Thursday. So I'm still recovering. But I hope you can hear me well enough. Okay. All right. Thank you. All right, so basically what we're going to discuss today is the work that I've set out for you under week 5. Right. So firstly, I hope that all of you are still keeping to our agreement that you are attending at least one Zoom session in a week. Those of you who did not attend last week, because I see a lot of extra names today. Those of you who did not attend last week, that you at least watch the Zoom consult, the video or the recording, right? So, okay, so that is the one thing. Number 2, that you're still setting aside 2 hours per week to read through the materials. Now, those of you who have done that would know now that with regard to the test, remember the test is coming up. The test was scheduled is scheduled for the 7th of September. Some of you have asked if we can move it, right? And the proposed date is the 9th of September. Please go on to Learn and please indicate for me what day, right? So whether it's the 7th, the 8th, or the 9th, what day you prefer. But otherwise, I've got no issue with moving it to the 9th. The scope of the test is, of course, the weeks. If we look at the weeks, week 1, 2, 3, and 4. So basically, it covers the introduction to SA law, right? And it covers week 3 and week 4, the general principles of contract. So basically up to where we did last week, up to capacity, right? And I said that the test will cover or will consist of MCQs and short answer questions that you will answer online. It will be 60 minutes long, or you will have 60 minutes to complete it. Most students complete it well within the time frame, because the MCQs doesn't take too long, right? And yes, so that is happening in that the 7th, 8th, or the 9th, depending on what you prefer, the test. So those of you who have already set aside 2 hours per week going through the materials, you've already done half of the work, right? I would say just go through the notes again, go through the slides again, and you should be fine for the test. Those of you who haven't looked at anything so far, yes, you'll definitely have to put some time aside and study for the test. Okay. Yes. Okay, so thanks for that. Class assignment number 2. I thought class assignment number 2 is going to cover this work that we're doing now. So basically week 5, and then also week 6. So I will probably only post that next week. I wanted, with regard to the class assignment, I said that you should only submit that class assignment after test 1. So I didn't want you to do class assignment 2 and study for test 1 at the same time. So that will probably be the week after, like the 15th of September, or just before the September break, etc. Okay. All right, thank you for those. Yes. All right, so people, remember I said, when we look at the general principles of a contract, it's going to become a little bit more difficult as it goes along, right? What we're looking at today is we looking at what are the other requirements for a contract. And remember, we say the general requirements for contract. So today we're going to talk about possibility of performance. So that is the first one, that the contract must be possible to perform. It must be possible for the parties to the contract to hand over the goods, to pay the price, to perform in terms of that contract. So possibility of performance, the one. Number two, certainty. The contract terms must be certain. The parties must know what they are getting into. Then number three, consent. There must be consent. And number four, then I said, let's look at agreement, offer and acceptance lastly. Okay, so those are the four things that you need to go through for this week, right? So let's start with possibility of performance. Remember, we said that if you look at a contract, when the parties enter into the contract, it must be possible for them to perform in terms of that contract. So that means it must be possible for them to do what they agree they're going to do, right? You will see with the slides, I set out and I say, if it is impossible to perform at the time that they enter into that contract, then that contract is void, right? The contract is void. Why? Because the law says you cannot enter into a contract to do something that it is impossible to do. If you and I enter into an agreement where I sell you the moon, for example, for 50,000 Rand, that contract is void. Why? Because I can never sell you that. I can never hand over that item. Right. So where it is impossible at the beginning, when they enter into the contract, that contract will be void. But what happens where they enter into a contract and something happens and it becomes impossible to perform after the contract? So then it might be that the contract is voidable. So the one party might go to court and ask the court to declare that contract voidable, to declare that contract, to set the contract aside, right? And on the slides, I want you to have a look at page 7, right? So make a note there, page 7 of the slides on possibility of performance. It says, for a person to escape liability, the person will have to prove certain things, right? So have a look at that. What it comes down to basically is that if you are the one asking for the contract to be set aside because of impossibility of performance, then you cannot be responsible for that. Huh? So if you and I enter into a contract that I will sell you my car for 50,000 Rand, you pay the 50,000 Rand, and I, instead of selling the car, I set the car alight and I destroy the car, right? So then I cannot go to court and ask the court to set aside the contract because I was the one responsible. So if you look at page 7 of the slides, it shows there what must a person prove to set aside a contract in terms of possibility. Okay. One thing that I made a note of is the issue of temporary impossibility. Now, temporary impossibility will not set aside the contract. If it is impossible to perform for a small limited amount of time, then the contract will be suspended. The court will not set aside that contract, right? So where it is temporarily impossible, performance is merely suspended. Counter performance is also suspended. So the one person will not be forced to, let's say, hand over the car, but the other person will also be able to withhold payment until that car is handed over, right? And where it is temporary impossible, right? So for a limited time impossibility, then neither party may cancel the contract, right? So then you cannot cancel the contract, then you are bound to that. So have a look. I think the issue of possibility of performance is quite clear. There shouldn't be any issues there. Have a look, as I say, at page 7 of the slides that says, what must a person prove where he wants to set aside a contract where the performance of that contract has now become impossible? And one of the key things there is that you will have to show that it's not your fault, right? That something happened, that there was what they call an act of God or vis major or so, an act of state that makes it impossible for you to perform. All right. Okay, let me just see here under the chats. Okay. All right. So that is the one. The second requirement, I say now second for today, is the issue of certainty. And I made the smallest little notes. I said that an agreement must be sufficiently certain. It must not be vague, right? So the court, when the court or an objective third party looks at the agreement, that third party must be able to see what is happening in the agreement. What kind of agreement is that? What is the purchase price? What is the thing that's being sold, etc. Right? So when it comes to to certainty, right? So with certainty, the clauses in the agreement must be certain. If there's any uncertain clauses, then the agreement will be void. So if the court looks at the contract and the court says, we do not know if this is a lease agreement or a sale agreement, then the court will set aside that contract. Why? Based on that the terms are not certain. Right. So have a look at that. It is very short, I think 13 pages just on certainty, but that is basically the requirement for certainty. Okay. Our focus for this week must be on the issue of consent, right? And consent is the next. So remember, it says, if you look at the essential requirements for a contract, that there must be an agreement, right? If we say an agreement, then we are saying that the parties must have voluntarily agreed to this contract. It's no point if you want to hold a gun to someone's head and you tell them sign the contract, then that is not consent. That is not an agreement. It is not a meeting of minds, right? So I say with consent, if there's no consent, it means there's no genuine agreement. If there's no agreement, it means that there was no meeting of minds. There were no consensus between the parties. Right. Now think about what can happen that will negate consent. If we say negate consent, that will take away the consent of the parties. So the parties agree to an agreement, but there's no consent for some other reason. And there are basically 4 items. The first one is if there was a mistake between the parties. So it might be that one of the parties are mistaken, or that both of the parties are mistaken, or that both of the parties are mistaken but about different things, right? So the first thing that will negate, take away consent is mistake. The second one is duress. The third one is undue influence. And the fourth one is misrepresentation. So this is, if you look at consent part 1, the slide set out then mistake, duress, undue influence. And then in part 2, we set out misrepresentation. We talk about that, right? Now, just to think about that, mistake means that the parties are mistaken about something, right? Mistake in itself shows or says that there is no intentional mistake, right? The parties are mistaken. It wasn't clear as to what is the contract price. It wasn't clear as to what is the thing being sold, for example, So mistake can have an effect on consent, right? Undue, now let's talk about duress. What is duress? Duress is where you threaten someone or force someone to enter into the agreement, right? Duress, where someone is forced, and they are threatened with assault. I'm going to beat you up if you don't sign this contract. You will see under duress, that is on page 28 and 29 of the slide, right, that the courts say that with duress, there's no meeting of minds. There's no voluntary agreement, and so that contract is voidable. The party who was forced to enter into that contract can go to court and ask the court to set aside the contract. Right? So duress means forcing a person through violence, through assault, through threat of assault, through, I don't know, blackmail, to enter into a contract, to sign a contract. So that is duress. The party can go to court and ask the court to set aside the contract. What is undue influence? Right? So I'm jumping around a bit, but undue influence. Undue influence is where a person was not threatened, but he was influenced by someone, maybe in a position of authority, or by someone that he respects, to enter into a contract. And that person worked on this, let's say, on the contracting party's resistance, right? So there wasn't a threat, but the person influenced him unlawfully or unduly so. So where would that be? If, for example, we had cases where, especially, well, we had cases where a priest would speak to someone who is, say, in stage 4 cancer, one of his, the church members, right? And the priest would speak to him and say, no, the only way that you will, book your place in heaven is if you donate this to the church. And the priest would unduly influence this church member to sign over all his assets to the church, or worse, even to sign over all the assets to the priest. So even though the court would say, even though there's a contract, that the parties have an agreement that this church member was not forced to enter into the agreement, there was undue influence, right? Now, undue influence is only in certain instances where there is some position of authority or where there's some position of respect, right? Sorry about that. So, for example, where you have a priest and a member of the church, or where you have a doctor, the surgeon that is over his client with stage 4 cancer, and this surgeon, this doctor, convinces the client to leave him assets in his will, right? That is all undue influence. Now, these kind of contracts, duress and undue influence, is voidable. So the contract will stand, but if someone challenges the contract to say that I was forced to do so, or that I was influenced, unlawfully influenced or undue influence to enter into this contract, it means that the court can set aside those contracts. Right. So if we look at consent, consent is necessary. It must be free and voluntary consent to enter into the agreement. We say that duress and undue influence will set aside that contract if, well, you can challenge it and ask the court to set it aside. What about mistake, where the parties made a mistake? And so here, please have a look at the slides. It's part 1 of consent. I set out and I say that there are different forms of mistake, right? The court only recognizes, or let's say the law only recognizes mistake of fact, right? So where there's a mistake in the effects of the contract, or mistake of fact in terms of the contract, that will have an effect. Right? But let's have, what is the other forms of mistake? Mistake of law, where a person says, I read the contract, but I did not understand certain clauses in the contract. That will not set aside the contract. The court is going to say, well, it was your duty, if you didn't understand things, to ask and to get clarity on certain things. So a mistake of law will not set aside the contract. A mistake in expression, where a person signs the contract but says, I didn't read the contract, but I've signed the contract, I've initialed every page. There the court says that will not affect the contract. You're supposed to know when you sign a contract what the clauses are. And then the mistake in motive, where a person enters into a contract because of some or other reason, right? So, for example, I think that my car was stolen. I immediately go and I buy a new car. I enter into a contract to purchase a new car. And then 2 weeks later, my son brings the car back and he says, oh, he was out joyriding somewhere, and the car was never stolen. I cannot go to the dealership and then say, oh, I made a mistake. My car wasn't stolen. I want to give back the new car. Right. So mistake of law, mistake of expression, and mistake of motive has no effect on the contract. Only mistake of fact. And so mistake of fact means where you are mistaken as to the nature of the contract. So you think this is a contract of sale, and meantime, it is a contract, a donation, So the item is merely being donated. Or you think the contract relates to a specific car, say a VW Polo 1600 2002 model. But in fact, the contract says a VW Polo 1400 2011 model. Right. So those kind of mistakes, those will have an effect on the contract, and those you can set aside. So I say that any party where there's a mistake in the contract, a mistake of fact relating to the type of contract, to the thing of the contract, the item, say the specific make and model of the car, to the attributes or the quality, whether that car is 20,000 kilometers or 120,000 kilometers. Right? Any party can go to court and ask the court to set aside this contract. Right? You can apply to court to declare this contract void because of the mistake of fact. And if the court does that, the court will say that because of undue enrichment, you have to give back. If you've already paid the price for that car, that price has to be returned. And if you've used the car, you might have to pay a reasonable amount for the usage of the car, like a rental of the car for that period. But the point is, when it comes to mistake, some mistakes the court says will not affect the contract. Mistake of law, mistake of expression, mistake of motive does not affect the contract. A mistake of fact will affect the contract if that mistake was reasonable and if it was material, right? If it was reasonable and if it was material. And that will make the contract void, right? If you can show, if you go to court and you want to ask the court to set aside that contract, if you can show that the contract that that mistake that you made, that a reasonable person would also make the same mistake, right? That that mistake had a material effect on the contract. You would never have paid that amount for that car if you had known that was the kilometers, say, on that vehicle. So that with mistake, right? So if you look at consent, the things that affect consent, mistake of fact will affect consent if it is a reasonable mistake, and if it was a material mistake, it would drastically have affected whether you wanted to buy that vehicle or not. Duress and undue influence also affects the contract and the way you enter into that contract. Okay. Now, remember, I said part of consent also then includes misrepresentation. What is a misrepresentation? A misrepresentation is where someone tells you something that is untrue, right? And so we have different forms of misrepresentation. So you can have a misrepresentation where it is an innocent misrepresentation, right? So the party who tells the other party, let's say the seller, tells the buyer, this vehicle is in perfect condition, has never been in an accident, right? If he does not know, if it is an innocent misrepresentation, the buyer can still go to court and ask the court to set aside the contract. Tell the court that if he knew that the vehicle was in an accident before, he would never have purchased it. Right. So an innocent misrepresentation. You also get a negligent misrepresentation. So negligent means where the other party, where the seller did not know, but he ought to have known. A reasonable person in the position of the seller would have researched or would have looked at the log books or the maintenance and repairs for that vehicle and would have been able to identify that the vehicle has been in an accident before. So with negligent misrepresentation, the party, the buyer, the party who was wronged, can ask the court for specific performance or for a ground of cancellation. Right? So specific performance can say that the seller must hand over the car, but that there will be a reduction in the price. Or he can ask that the contract be cancelled. And then the worst one that you have there under misrepresentation is the issue of fraudulent misrepresentation. If a person on purpose intentionally misrepresents a fact in terms of a contract, not only does that person is the person guilty of a crime, well, we say guilty of a crime, it's fraud, right? Where you intentionally misrepresent a fact to cause someone else harm. Right? So if this is the seller is a motor dealership who knows the vehicle was in an accident, who tries to hide that history of the vehicle from the buyer, who tells the buyer that this vehicle has never been in an accident, guaranteed, and that is why the price is this price. That is a false fact. It is intentional. Apart from being a crime or fraud, it also will help the buyer to set aside the contract, to claim damages, right, if there was any damages, or to ask for return of that purchase price, right? So you can have a ground of cancellation and restitutio, which means to return whatever you have paid, and you can claim damages in that case. And that is where we have misrepresentation, right? So misrepresentation also affects the consent part of a contract, because misrepresentation says that this party would never have freely and voluntarily consented to this contract if he had known the true facts of the case. So if he had known what the real facts were and what the true stance of that item was. So that with misrepresentation. So mistake, undue influence, duress, and misrepresentation has an effect on a contract, right? With mistake, where it is a mistake of fact, where it is a reasonable mistake, and where it's a material mistake, the party can go to court and ask the court to set it aside. With duress and undue influence, the party can go to court and show the court that I was forced to enter into this contract, or that there was undue influence, right? It was a doctor, patient, a priest, and a parishioner, etc. A kind of relationship. And with misrepresentation, he has to show whether the other party was innocent, whether the other party was negligent, or whether the other party had fraudulent intent, right? And the worse it goes with fraudulent intent, you can claim damages, you can claim restitution. That means giving back what you've already paid, must be paid back. There can be some penalty being paid. It's a ground of cancellation, etc. Okay. Any questions? Any questions on that? Let me just try to get a... So I am sure that if you read through the slides, right, and the examples that I've given in the slides, that when you see the test questions, right, the MCQs, it will be easy for you to answer that. And keep in mind that we go, yes, I know that when you answer the test question, you're going to have your textbook there with you, right? Or you're going to print out all your notes and you're going to have a look at the notes. I understand that. But still, you need to go through the work beforehand. You need to read through everything so that you know where to look at least, right? You have to prepare, you have to read and make sure that you understand just the basic concepts of this when we look at the requirements. Now, week 5 then also includes the last thing, which I would say is the most important thing for any contract, is that there must be an agreement to the contract, right? And I have uploaded 2 sets of slides on agreement, part 1 and part 2. Part 2 is, you can read through that easily. I don't think that is, you know, that there are any difficult concepts there with part 2. But for part 1, definitely, how do we enter into a contract? Right? You say that the parties must agree to the contract. I go, okay, but what does that mean? How do you know if someone has agreed? And agreed to what? You know, to what do they agree? Yeah, sorry about that. So if we talk about the agreement part, right? Agreement means that there must be an offer and acceptance, There must be an offer and acceptance. Someone needs to make an offer, needs to say that I would like to purchase your car for 20,000 Rand. That is the offer, right? That agreement is only concluded where the other party accepts the offer. So that is why we talk about an offer and acceptance. Offer plus acceptance is the agreement, right? An agreement needs both of those. And acceptance, if we talk about acceptance, acceptance must be of the entire offer. If I, for example, so if I tell you, I want to purchase your car for 20,000 Rand, that VW Polo that you have there, I want to buy that car for 20,000 Rand, right? If you say yes, then it means you have accepted that offer and the contract, there is an agreement to that, right? If you say you would consider selling it to me, but not for 20,000, at least for, at minimum 50,000 Rand, right? Then there is no agreement, right? Because the agreement is only when you accept my offer. So if you say you would sell it, but for 50,000, then it means there's a new offer. You are now offering to sell that vehicle for 50,000, and I then can accept or not. If I say no, I would buy it for 40,000, then it means there's a new offer, right? So do you understand? Acceptance must be of the entire offer. As soon as you do a conditional acceptance, as soon as you accept part of the offer, but you want to change something in that offer, then it becomes a new agreement, a new offer. Right? So you would see on page, you would see on page 13 of the slides, they talk about the theories of acceptance, right? So that means where a person accepts, the question is always, where does the contract come into play, right? If a person accepts, if you call them and you speak to them over the phone, right, and the person accepts the offer, right, where does that contract come into play? And so you will see there a telephone. If a person speaks to you on a telephone, there they follow the information theory, right? The information theory, where you send your acceptance via post. Nobody does that with the SA post office. There you have to use the expedition theory, and with an email or a WhatsApp, there we're going to look at the reception theory, right? So these are just theories, and I see it's on page 12 and page 13 of the notes. So what does it say? That, let's say, the information theory. So when you speak to someone over the phone and that person hears what you are saying, right? It's not a voice note. It's not a voicemail or a little WhatsApp note. When you speak to a person, says when the information theory says when the letter of acceptance or that acceptance reaches the mind of the offerer, right, that contract is concluded. So as soon as you speak to someone over the phone, that contract is then concluded immediately. Right? It might be that the parties, for example, this morning I called the insurance company, that the parties say, yes, we have spoken over the phone. We will now send you a written confirmation, which you have to sign and send back to us. Remember, that is then a formality that the parties agree. We're going to send, you're going to sign, you're going to send it back. Okay. With an email or WhatsApp, let's say if you have made the offer to me and I email you, or I send you a WhatsApp and I say, yes, I agree 20,000 rand for that vehicle would be enough. Right. It says the reception theory applies, and the reception theory says when the letter of acceptance, where that acceptance reaches the offerer's address, even if that person has not read the contract or read your acceptance, as soon as you can show that the thing was delivered to that address, then there would be a contract, there would be an offer and an acceptance. Now, why is this important? Is to say that where one party, right, the offerer, makes an offer to someone else, that offer is not going to be on the table for the rest of time, right, till the end of time. There will be a reasonable time for that person to accept the offer or not. If that person does not accept the offer immediately, and let's say the offer is open for 2 weeks' time, then the person who made the offer can withdraw the offer again. So if I offer and I say, I want to buy your VW Polo for 20,000 rand, and you don't respond to that, it's not going to be forever, right? So then I can let you know and say, listen, I haven't heard anything from you. I am withdrawing this offer, or I am going to look for something else. Right? So the person who makes the offer can either say, this offer is available for 2 weeks, right? Or that person can say, if there's no time frame, we can say that the person has a reasonable time to accept. If that person does not accept within that reasonable time, let's say reasonable time should be about 2 weeks, 14 days, then you can withdraw the offer, you can retract the offer. Now, something that I thought you should have a look at, right, which is very interesting always, is the issue of special terms to a contract. If you enter into any contract, right, and there are special terms, you will see with, let's say, an insurance contract that the insurance provider, right, OUTsurance, will tell you they have to read a few things, right? You have no idea what it means, and they go through it as fast as they can because they're recording it just to tick off the little boxes to say, but we have informed you of all these items. Right? Special terms. A party who wants to introduce a special term to a contract has to identify. A party who wants to introduce a special term has to identify those terms to the other party, right? So if I have a hotel and I want to say that I'm not liable for any loss whatsoever on this on the premises, that yes, I'm not liable for any loss on the premises, then I have to include that in the contract. And I will have to draw your attention to that. So you would see if you go to, well, any place, if you go to a hotel, if you go to a mall, right, there's always a disclaimer. A disclaimer saying anyone entering the premises do so at their own risk, right? And the owner of the premises will not be liable for any death or injury or destruction or what caused in terms of that. Now, those kind of notices, those disclaimers, those are valid. You can have those disclaimers. Every guest house will have a disclaimer like that. Every mall will have disclaimers like that. But in order for that to form part of the agreement, you, the guest house, will have to show that the party, the guest who is staying there, right, knew about that he saw those posters were placed at the front gates, it was placed at reception, it is part of the contract where he signs the contract, or he signs receipt for the keys for the room, it is on that contract as well. So have a look at that. It is on page 16 to 21 of the slide, talking about signs and notices. Right. So signs and notices, it must be brought to the attention of the other party. You will have to show that the other party saw this or should reasonably have seen these posters, these warnings, these signs and notices. Right. So that is when we look at an agreement. There's an offer, there's an acceptance. Make sure that your acceptance is in terms of that offer. Any conditional acceptance means that that offer was not accepted, that there's now a new offer. So it creates a new one. Right. Have a look at those signs and notices. Any special terms, warnings, disclaimers and stuff must be brought to the attention of the guests or of third parties. How do you show that? You show that they've signed, that they saw this, or that a reasonable person would have seen it. It was displayed at prominent places all over the property. Right. And so that then becomes a special term that forms part of the contract or of the agreement. So people, I think, let me just have a look. So as for today, remember week 5 is not going to be tested in test 1. Right. I will do week 5 with the class assignment number 2, and then week 6, what we're going to do next week, breach of contract, termination, etc. That will form part of test 2. Right. So the idea is still that we have test 1, the 7th, 8th, or the 9th is the proposed date. Have a look on Learn. I've created that little quiz or poll just to make sure that everyone is fine with the 9th of September. And then test 2 will be in October. Test 3 will be beginning of November. Remember, if you cannot write test 1 because you are sick, remember there's no, there is no deferral of tests. So you cannot say, oh, I didn't want to write the test, so I'm going to write another test. Right. You have to write test 1, 2, and 3. If you are sick, or if you have load shedding, or if you have whatever reason you cannot write a test, you have to apply for the AgroTat test. Right. Remember, we've got our tests and then an AgroTat for each one of the tests. Only at the end of the term, at the end of, after you've written all 3 tests, then we will have a catch-up test, an additional test for those who have failed, who need to get extra marks to put them through. Then we will have a test. It's in the module outline. You can have a look at that, and we will definitely speak about that again. Okay. But people, I want to say thank you very much for bearing with me. I know it's not been the most clear with regard to the presentation, but I hope if there's questions that you will email me, and I'm going to see the other group again at 2 o'clock, I hope.